Trading patents in stealth mode. This presentation explains why both patent buyers and sellers often wish to remain anonymous in patent sale negotiations, and how intermediaries can play an important role in facilitating discrete, stealth mode transactions. There are good reasons for companies involved in patent trading to fly under the radar. Patent activity signals a company's product strategy and future directions. Your competitors may be very interested to learn that you're buying or selling patents in a particular field of technology. Looking to buy patents in a particular area can disclose a company's weaknesses. Disclosing your weaknesses to your enemies is never recommended. Shielding your identity can often help you negotiate better terms. A seller is apt to increase the price if he knows the buyer is awash with cash. Likewise, buyers are inclined to offer low prices if they know the seller is short of money. To avoid bias in how offers and counteroffers are set, it's sometimes necessary to withhold the identity of a party until the early stages of the transaction. As we'll learn in upcoming slides, trading patents in stealth mode can reduce the risk of infringement-based litigation for the seller as well as the buyer. There's a correlation between operating companies that are buying patents and companies that are infringing those patents. Why would the buyer be interested if it was not actively involved in the field of the invention? Some patent buyers are concerned that the seller has placed the patents on the market as a deliberate ploy to uncover infringers. Once it's found the identity of the potential buyer, the patent holder is then able to investigate infringement with a view to bringing a lawsuit. Genuine and friendly negotiations about acquiring a patent have sometimes been transformed into threatening discussions and legal action. As a result of these concerns about infringement lawsuits, patent buyers are increasingly cautious about disclosing their identity to sellers. Sellers are also justifiably concerned about triggering lawsuits. As a seller, you may see little danger in approaching a potential buyer, informing them of your patent and suggesting they license or buy the patent from you. This would be reasonable and normal sales activity when selling virtually anything except a patent. However, a potential buyer that receives this approach could perceive it as the prelude to an infringement lawsuit, as many patent infringement suits start out in the very same way. The company is put on notice of the patent and license or acquisition is suggested. A buyer with a reasonable fear of an infringement suit has the right to strike first, bringing a lawsuit for declaratory judgment, essentially asking the court to determine if infringement is taking place, so as to clear the cloud of uncertainty hanging over the parties. A patent infringement claim is compulsory in reaction to a request for a declaratory judgment. So, the potential buyer is able to trigger a complete infringement suit upon receipt of an approach from a patent seller. The buyer not only has the right to trigger a lawsuit, but there are compelling reasons for them to do so. By bringing the suit, the buyer can select the venue for the case. The potential infringer will want to bring the case in the federal court that's most convenient and friendly to the defendant, whereas the plaintiff, the patent holder, is going to want the case heard in a plaintiff-friendly venue, such as Eastern Texas. In recent years, the federal court in the Eastern District of Texas has developed a reputation as favoring the plaintiff. Eastern Texas juries are apt to find infringement where juries in other federal districts may not. The incentive for the accused infringer to bring the case first and prevent the case from being brought by the patent holder in Eastern Texas is compelling. The legal fees and associated costs of such a lawsuit are a significant financial burden on both sides, so patent sellers are justifiably concerned and often wish to promote their patents using stealth mode approach. When awarding damages for patent infringement, the court assesses a reasonable royalty that the infringer is then forced to pay to the patent holder. If the infringement took place knowingly, the infringer was aware of the patent and continued to infringe it, the court can multiply the royalty by a factor of 3. By sending your patent number to a potential buyer, you're effectively putting the buyer on notice of the patent, and this can trigger triple damages from the resulting lawsuit. It's no surprise then that many buyers request that sellers do not send them patent numbers or inform them of the existence of any patents in their field of business. Patent attorneys don't want to be put on notice of patents for another reason. When filing new patent applications, the attorney has a duty to inform the Patent Office of any prior art, including other patents that the attorney is aware of. Patent attorneys don't want to receive patent numbers from buyers or otherwise be put on notice of a patent, as this then triggers the duty to disclose this knowledge to the Patent Office. Being on notice of patents can hamper the attorney's ability to prosecute new patent applications. So don't be surprised when you hear patent attorneys and potential buyers say, "Please don't tell me about your patent." They're not insulting you or your patents, just trying to avoid triple damages in a potential lawsuit and trying to keep the disclosures to the Patent Office to a minimum. Both for sale and wanted listings on the Tynax exchange are anonymous. They're designed to describe the opportunity without disclosing the patent numbers or the identity of the lister. The listing is intended as a teaser, to encourage serious readers to submit a Tell Me More inquiry together with their name and contact details. A Tynax representative then follows up with the inquirer to qualify and assess their level of interest. With the approval of the lister, confidentiality agreements are put in place before the parties are introduced and sensitive information then disclosed. It is possible to create listings on the Tynax exchange that are not only anonymous, but they're also unavailable to the public. These private listings are available only to the lister, Tynax staff, and invited prospects. These listings are extremely confidential, but marketing reach is constrained as they cannot be syndicated to the brokers on the Tynax exchange or circulated extensively online. Confidentiality agreements can protect the interests of both buyers and sellers in patent sale transactions. After providing the anonymous listing and qualifying the prospect, Tynax encourages and helps its clients to put these NDA agreements in place before disclosing confidential information such as patent numbers, the identities of the parties, infringement and licensing information. Patent buyers sometimes operate through shell companies, trusts, and various forms of subsidiaries in order to maintain their anonymity. Patents are often acquired by these subsidiaries of undisclosed parents. So, patent trading often takes place under a veil of secrecy. Buyers and sellers take measures to maintain their anonymity. Discrete transactions can take place via anonymous listings and shell companies with undisclosed parents. The Tynax exchange, its network of brokers, buying agents, and other intermediaries, is set up to facilitate stealth mode trading and protect the interests of both buyers and sellers in patent transfer transactions.